If you're facing a sentencing hearing, start raising your level of confidence with solid preparations. The more you know about the process, the more effectively that you are going to be when you start working with your lawyer. My name is Michael Santos. I am with Prison Professors, and if you visit our website, you're going to learn a lot about this whole process, about how to prepare for government investigations, sentencing hearings, or prison if that's where you're going. But our mission is to help you get the best possible outcome regardless of what stage of the proceedings you're in. And so we publish a lot of information here on YouTube or on iTunes, and we hope that you will subscribe, but we also hope that you'll visit our website and take advantage of the information that we offer to try and help people prepare for the best possible outcome. Because if authorities have targeted you for a government investigation or a crime, then it's crucial that you start to learn as much as you possibly can, as soon as you possibly can. You see, it's very difficult to really understand all the complexities of the judicial system and all of the the challenges that follow after. And so we want to give you this basic understanding of why you should begin preparing for sentence mitigation at the soonest possible time. Because if there is a government investigation or there is a criminal charge, in most cases, a sentencing hearing will follow. Now, to be fully transparent, you should know a little bit about who I am and the perspective from which I'm communicating. My name is Michael Santos, as I have said, and I have published volumes of content about my journey. But if you haven't seen any of that history, at the very least, you should know the backstory. And the backstory is that I made a lot of really bad decisions when I was a young man. And as a result of those bad decisions, and also because of my ignorance of the system, I got sentenced to a very long term, and I served 26 years in federal prisons of every security level. Now, the information is really relevant to you for a couple of reasons. Number one, I want my audience to know that I'm not dispensing legal advice. I'm not a lawyer. But number two, what I am doing is I am dispensing information that I wish I would have had at the very earliest stages of my proceedings, because I would have made different decisions and it would have influenced my sentencing. So, although the lawyer that is representing you will likely prepare a sentencing memorandum for the judge, and the lawyer may not have time to really keep you apprised of all of the different stages of the process. But those who don't know the sentencing process really miss out on an opportunity to engineer a pathway that is going to lead them to the best possible outcome. So such lessons would have been enormously helpful to me at the start of my journey, and that's why I've worked so hard to prepare as much information as I possibly can to help as many people as possible. So what do you need to know if you have become the target of a criminal investigation, or if you have been charged? Well, the simple answer is a lot. You can't just outsource all of the decisions to your attorney. Many people that face law enforcement challenges make decisions that really exacerbate their problems. They don't mean to worsen their troubles by not preparing for court, but they just don't know and they don't take the time to learn. You see, if you don't understand what's coming or what options are available, then it's very possible that you're feeling vulnerable and you're not able to sleep. So I think everyone would agree with this premise that it's better to be knowledgeable and aware of what's coming than to not know anything. And targets of both civil and criminal investigations can unwittingly talk themselves into a criminal indictment. They may eliminate opportunities for a diversion program that would keep them out of jail. Or they may expose themselves to more stringent sanctions. So the more you know, the more effective that you are going to be. And that's why our entire team at Prison Professors, which includes several sentence mitigation experts, provides this primer on the system. Because with knowledge, a person can start to feel a little bit more competent as he interacts with his criminal defense attorney. And on the flip side, a person without knowledge will always feel weaker, as if he is in a position of darkness, never knowing what's around the next turn. So let's paraphrase an old Chinese proverb. If you want to know the road ahead, ask someone that has come back. So operating without knowledge makes us feel as if we're hanging from a string, as if we're some type of marionette puppet with, prosecutors, pulling the strings and a probation officer pulling the strings, wondering what a judge is going to do or what a defense attorney is going to do. And you got to stop that feeling of helplessness and start restoring confidence. And in order to restore confidence, we need to develop a better understanding of what's coming. We need to really get a good grasp of what can we possibly do. So defendants learn quickly that problems with the criminal justice system can lead to enormous costs. And I'm not only talking about money, right? I'm also talking about the costs of losing your liberty, the costs of future earning power, the costs of being separated from family, and then the ancillary collateral consequences that follow, like access to banking and financing and housing and career opportunities. All of that can linger for a lifetime. And you don't have to take my word for it. These are easily verifiable statistics that show the fallout for those who have been targeted by the criminal justice system. So it's crucial to prepare, and it makes a great deal of sense to learn as much as possible. Now, the learning process really begins with the reality that many people get sucked into the criminal justice system without really even understanding how. But although going through the system is difficult, there are some best practiced ways to prepare. See, according to a 2019 report by the Prison Policy Initiative, the American criminal justice system incarcerates more than 2.3 million people. Now, not everyone that goes into the system gets the best outcome. Those that learn can prepare far more effectively than those who don't learn. And by learning about the system, people facing criminal charges put themselves in a far different algorithm. They start to frame possibilities for a better outcome. Once a person becomes a target, it is essential to start tapping into all of our critical thinking skills. We have got to contemplate what ways that we can pursue to influence decision makers. And a person's mitigation strategy should result in stakeholders viewing that person from a completely different lens. See, a prudent defendant will work to create a story, one that will help others see him as a fellow human being rather than as a cog to grind through the criminal justice machine. All people facing challenges with the criminal justice system share common traits. Their family members, their friends, their colleagues, they all care about them. And defendants would like to live in a world where investigators and prosecutors and probation officers and judges also see them as ordinary citizens. But prosecutors may charge people with a crime, and defendants, like all people, have many attributes that are reflective of their character. But that crime, the prosecutors may not see as an aberration or a one-time act that is contextual and doesn't really resemble how the person would behave in most circumstances. But that doesn't matter. Once a person comes into the criminal justice system and he becomes a target for prosecution, stakeholders in the system are going to start turning their attention to the alleged criminal wrongdoing, and that's all they're going to see. A criminal charge can really stop stakeholders from looking at a person as a human being. And in an instant, that person becomes a defendant. And the goal or the objective for the prosecutors is not always justice. Some prosecutors want a conviction followed by a very punitive sanction. And that also goes for government investigations, which is why our team at Prison Professors produces so much content, even for people that are starting in civil proceedings, like whether it's with the SEC or the FTC or the FDA. All of those investigations can eventually turn into a criminal problem. So the prudent individual is always going to introspect. He's always going to start asking questions about what he can do to begin preparing for a better outcome. You see, a target of a criminal investigation would like to find some type of diversionary program to avoid prosecution. And, if they are prosecuted, they want the best possible outcome, but that's not going to happen by accident. You see, most people need to start preparing for the best results. And the best results for most are going to be the least restrictive or least punitive sanction, preferably a sentence that does not take away a person's liberty. But how does a person go about getting the best possible outcome? Well, unfortunately, statistics show that few people who encounter the criminal justice system really know how to position themselves for the best possible result. And for that reason, we want everyone who becomes the target of a prosecution or a government investigation to start thinking about how to architect that effective sentence mitigation plan. I mean, consider this old saying about the best time to plant an oak tree. I heard a speaker ask that question to members of his audience, and predictably, the audience members started to venture out a guess. Some said it was in the morning, some said it was in the winter, some said it was in the summer. Nobody knew. No one had a clue. But pausing for dramatic effect, the speaker answered, the best time to plant an oak tree was 20 years ago. But the second best time is today. Well, we could say the same thing about a sentence mitigation plan. Too often, a defendant doesn't do anything to prepare for the sentencing hearing. And that's a mistake, but it's understandable. People don't necessarily think of themselves as criminals. But regardless of what type of activity brought a person to the attention of authorities, they want to believe that they are different and that the world is going to see them differently. They want to believe that they're immune from law enforcement. They may not know anyone who has ever been through the system, and they can't really conceive of themselves as going into the system. But how about you? How do you see yourself? You see, when federal authorities target a person for trial, their conviction rates exceed 85%. And with those odds, it just makes a lot of sense to begin thinking about a sentence mitigation strategy at the soonest possible time. Because it's not something you can do overnight. Regardless of what type of charge a person faces, it is essential to realize that sentencing proceedings are likely going to follow, particularly in the federal system. But this message doesn't only apply to the federal system, it applies to anybody, whether it is a driving offense, whether it is any type of offense that could result in the loss of liberty. You got to start with an understanding of what that what is going to follow with the sentencing proceeding. Start with an understanding of what the defense attorney is going to do. See, the defense attorney is likely going to work with the evidence against the person. He's going to work with the procedural rules that the court is going to require that he follow. He's going to follow the evidence and what the court is going to consider. He's going to follow the substantive law that Congress has passed or the case law that judges have decided in the past. And the prosecutor's ability to prove a case against the defendant is going to be of paramount importance to the defense attorney. You see, to succeed, the defense attorney will exercise judgment and discretion, fighting valiantly to get the best possible outcome for the defendant. But both the prosecutor and the defense attorney will be analyzing the case and pressing forward to get the result that they want. And rather than justice, the prosecutor is going to strive for a conviction. The defense attorney will parry the prosecutor's efforts, always assessing the strength of arguments that the prosecutor is going to use. That's why a defense attorney has to be a very good analytical thinker. But that doesn't always mean that he's a great listener. And the defense attorney may not really know so much about the defendant's life story. And so for that reason, every defendant should invest the time and the energy to present that life story. And that life story can make all the difference in the world when it comes to sentencing. Indeed, our team has worked closely with many people who have faced challenges, and we've also worked with many federal judges. We have spoken with dozens of federal judges about the importance of preparing for sentencing. And 2 of those federal judges actually sat for an interview with me. And if you watch the videos that are available on our website, you're going to learn a great deal from those interviews that I did with federal judges. You will see that I asked them about steps that a person could take to influence a judge's sentencing decision. And each judge that I spoke to, although only 2 appeared on camera, every judge I spoke to said that when it comes to sentencing, they really want to hear from defendants. Despite what the judges say, despite what those judges say, some defense attorneys really don't support a proactive sentence mitigation plan. Other defense attorneys, do support it, and others resist it. And why is the reason for that? Why would anybody resist a person's efforts to prepare for sentencing? Well, as I said earlier, attorneys are great analytical thinkers. And since they know it is the prosecutor's burden to prove a case, they operate out of an abundance of caution. They may not want to introduce any evidence that a prosecutor could use against their client. And since most defendants start with denial, incapable of fully appreciating the system or the charges against them, or at least how prosecutors look at them, they don't want to admit, they don't want to take responsibility, and sometimes they dig themselves into a deeper hole. And for that reason, defense attorneys sometimes they don't want to hear what the client has to say. So, that's just reality. The attorneys may have invested considerable amounts of time in constructing an elaborate defense, and they just don't want their clients to make statements that prosecutors may twist or turn around or use against the person when the defense attorney is fighting for leniency. But defense attorneys may rely upon case law, facts, and what the prosecutor could prove. But we really believe, after talking with many federal judges, and more importantly, talking with more than 1,000 people who have been sentenced, we really believe that it is important for an individual to help a federal judge really see the person differently. We want the judge to see that individual as a human being. And that's what an effective sentence mitigation strategy is all about. When a person creates and executes a very effective sentence mitigation strategy, that individual can be of an immense service to his defense attorney, because the defense attorney will be able to use that in his own preparations to lower the guy's sentence. So in our view, a sentence mitigation plan will strive to achieve several outcomes. Number one, it's going to help the judge understand a lot more about who the defendant is as an individual. Number two, it's going to help the judge grasp the influences that led the defendant into the current situation. And it's going to hear in the defendant's own words. It's going to help the judge see aspects of the defendant's life that could not be conveyed by the defense attorney's eloquence alone. It's going to help the judge see the defendant in his environment and really help the judge understand how the defendant interacts with his community, or why the defendant is worthy of mercy or leniency. And so engineering this effective sentence mitigation strategy does not excuse the misconduct, and nor would it even argue any of the facts of the case. In fact, a sentence mitigation plan should do just the opposite. It is a strategy to show the judge why the person is worthy of mercy. It would never serve a person's interest to minimize his liability or to blame anyone or anything else on his problems. If referring to the criminal conduct at all, the sentence mitigation strategy should really just focus on some key points, such as understanding and appreciating the victim's pain, suffering, or loss. And remember, it's not you're not building this case for your family. You've got an audience of one here, or an audience of the stakeholders, and regardless of what you think, they believe there's a victim. So you really want to emphasize that you identify with that victim. And you also want to show that what you've learned from this incident offense and what influences put you in this offense. You want to show what you've learned from the entire experience and what steps that you've taken to reconcile with society, with the victims and the community. And you also want to be able to articulate a very coherent plan that will show the reasons why the judge can rest assured that you're not going to break the law again. So, this, of course, I'm talking about pleading guilty, and, you may be wondering, well, what if I go to trial? And I understand that position. See, the vast majority of people that come into the system, they start with a not guilty plea. And then as their defense attorneys work through the evidence and the discovery, and they weigh the risks of going to trial versus working towards a plea agreement, in most cases, they negotiate a plea agreement that's as favorable as possible. But there is a small percentage of people who maintain their innocence and proceed through trial. I went through trial, but I was not innocent. I just made some really bad decisions. And again, going back to why I think it's so important to share those experiences with as many people as possible. You see, if a defendant proceeds through trial and is found guilty, that defendant may want to preserve rights for appeal. And in that case, a defendant will want to create a different kind of sentence mitigation plan, one that doesn't threaten the prospects for an appeal. So he should refrain from discussing any aspects of the case, but that doesn't mean he can't employ a strategy that focuses exclusively on helping the judge get to know the individual as a human being. There's always an opportunity to create a mitigation strategy. And it's equivalent to building a sales presentation, perhaps the biggest sale that a person is ever going to make. And how do we accomplish that goal? Well, we begin by thinking about the audience. Remember, a strategy has an audience of one, and that's the judge, at least at the start of the process. So what steps can you take to differentiate yourself from every other defendant that comes before the judge? That's the key. You got to take a first-person approach. You can let your lawyer argue the law and deal with the evidence against you, but when it comes to articulating the story of your life, I suggest that you use your own words in a first-person voice. See, from our perspective, this is just common sense. Your lawyer, after all, he's a professional, regardless of who hires him. This person is skilled in the arts of persuasion, and he's going to represent his client. Even if the most notorious criminal ever retained your defense attorney as a person of eloquence, he's going to do the best that he can to argue some type of mitigation on behalf of the client. And the judge knows that. After decades of practicing law, judges know specifically what defense attorneys are going to say. And they're all going to argue for some form of liberty or at least leniency. So when deliberating over the appropriate sentence, I am not so sure that the judge is so much concerned with the arguments that the defense attorney is going to say. I think that he also knows the case law and he knows what the prosecutor is going to say. But what he doesn't know is what the defendant is going to say. That's what can really move the needle. So before sentencing, a defendant has an opportunity to influence that outcome. That's what sentence mitigation is all about. A defendant does well when he starts from the premise that he's about to make the biggest sale of his life, as I said before. The only question is how well has he prepared, or how much time, energy, and resources has he invested to build a very powerful and persuasive and influential case. At Prison Professors, our team has developed a theory. You see, we believe that an effective sentence mitigation plan should begin at the soonest possible time. No one can change the past, but any of us can start crafting a story that will show who we are as people and how we got here. We are big believers in this three-tiered strategy that includes a personal sentencing narrative, a strategic character reference letter campaign, and a sentence mitigation story of community service. And as a bonus, you might even consider doing your own video, right? It's not that hard standing in front of a camera and tell us who you are. Based on what we've learned from judges, we believe that defendants serve themselves well when they write first-person sentencing narratives. So for defendants that have pled guilty, the sentencing narrative should adhere to the following 5 points. Number 1, show an understanding and an appreciation for the victim's pain, suffering, or loss. I think I didn't say that right. I think I missed out and said this is for the person who's pleaded guilty. You want to really accept responsibility, but also talk about the victim's pain, the suffering, or loss. And you can even do that, in fact, if you went to trial. Okay? You can express some appreciation for that. You can show the influences that led a person to become involved in this offense, and you can show what the person has learned from the experience. You can also talk about what you've learned or what you've done to reconcile with society, with the victims, and with the community to make things right. You can articulate a very coherent plan so that the judge knows, despite where you're standing, you don't really have a criminal heart or a criminal mind. You really want to be a part of the broader community. So if a judge or jury convicted the person after a trial, it's really essential to consider the appellate strategy. But either way, you've got to start constructing a narrative that will focus on the judge's perspective using this 5 points that I just described. We've worked with many people that have prepared effective sentencing strategies, even though they didn't accept responsibility before being convicted after a trial. Every case is different. There's no cookie-cutter, boilerplate approach to this. And there is no guarantee that a personal sentencing narrative is really going to influence the judge. But you've got to try. You've got to invest the effort to engineer this pathway that is going to put you in a better position than if you just remain silent. No one should leave the courtroom no one should allow the judge to leave the courtroom without complete clarity about his mindset, the defendant's mindset, and what influences led him into this predicament at hand. So now remember some basic lessons here. When creating a well-structured letter, you've got to start by thinking about the audience. And your audience is a judge. Right? Judges get inundated with paperwork, and when they're crafting a message, you've got to be thinking about length. And our recommendation is that you create a document of somewhere between 2,000 and 3,500 words maybe. Some narratives may go a little bit longer, but in our experience, we found that word count to be, of 2,000, 3,500 words, somewhere in there is really the sweet spot, because it's not too long, and you can really create a structured, tiered approach of the argument that you're trying to make. But the art of writing is rewriting. You see, you got to write over and over again. Take time to get it right. Ask others to read through the document. Have your readers give you a sense of what you can do to improve it. Get as much guidance as you possibly can. And when it's complete, share the letter with your defense attorney and consider his advice on steps that he may suggest to strengthen the document. Just make sure that it shows who you are as a person. Now, the second component of a good sentence mitigation strategy is to think about this well-choreographed character reference letter campaign. Now, in other areas of our site at Prison Professors or on our YouTube channel, we provide content on what is a character reference letter, what does it look like, what should it look like, how long should it be, who should it come from, what should they say, but more importantly, what they should not say. You see, defense attorneys do not want to hear from somebody who's going to tell them how to do their job. What they want to hear is somebody that talks about the person's character. For example, did you help your neighbor mow the lawn? Did you shovel snow for somebody? Did you coach a little league team? Did you volunteer in the community? What is your character like? Don't submit letters that talk about the crime or why you shouldn't be going to prison. And ideally, you've got to be thinking about who are you going to collect letters from. Should they be powerful people? Should they be people that you've known since childhood? Who should they be besides family members? I can tell you the judges with whom we have spoken said it's far more influential when they hear from somebody who's known that individual for a long time rather than getting a letter from some powerful, influential person that might be doing a favor or paying something back. So the character reference letters should never make excuses for what the person did. In fact, they probably shouldn't even reveal the crime other than the defendant, the person, really was honest and told them, hey, I'm in trouble. I'm in this situation and I'd like you to help me if you still find me worthy. That is, it takes a lot for somebody to go and ask somebody to step up when they've just been convicted of a crime. So take the time to understand the appropriate strategy for a character reference letter. Do as much research as you can. We offer a lot of content at Prison Professors, but at the end of the day, it's up to you to use your discretion on what steps you can take to prepare. And the last component of our program is really talking about developing a more comprehensive sentence mitigation strategy, and that is going to only be limited by your imagination. That could be books you could write, that could be courses you create, that could be opportunities to influence to an important community cause. You have to figure out how much time, energy, do you want to invest in this project of getting the lowest possible sentence. So we hope that this has been helpful to you. If you find value in these kinds of messages, please subscribe to Prison Professors. Besides trying to help people who are going into the system, we also create a tremendous amount of content that we bring into jails and prisons to teach and inspire people who are inside. So we would love it if you found value. Leave a comment to this video or subscribe to the channel, share it with others. And if you want to share your own story, reach out to us. I'm Michael at prisonprofessors.com. We've got an iTunes channel. Of course, our website has an abundance of information, books and courses to help anybody who's going into the system, regardless of what stage they're in. Just don't live like an ostrich with your head buried in the sand. Make sure that you learn as much as you can, and you take the time to architect a strategy that puts you in a far better position for success.